confusing, right? So I might make some mistake, and let me know, and I will take note and change that. Thank you very much. So feel free to do that. Okay, don't worry. Don't say, oh, she mistaken me with someone else, but then I'm scared I didn't want to tell her. So that is totally fine. Okay, just feel free to privately message me, and I will make sure that the name is corrected. Okay, next one. Sources of law in the U.S. law. What are they? Right. So common law of contract, right, and statutory law. What does it mean when we say common law of contract, everyone? What do we mean when we say common law of contracts?
I guess that common law of contracts are the early court decisions related to dispute of contracts.
Okay, the earlier decision of the court related to contract. Okay, thank you. Cho Long, right?
Yes.
Right. Anyone else? What do you guys think? Based on what you have learned, based on what you can recall, what does it mean when we say common law of contract? Exactly, right? So what Châu Long said is very precise. So as a major source of contract law, right, the common law of contracts actually developed from the earlier court decisions and then later on became precedent for later decisions, okay? And the common law actually governs all the contracts except what? Except when it has been modified or replaced by statutory law, such as like the Uniform Commercial Code or by any administrative agency regulations. Okay. So the background of it, right? Because the US has a colonial heritage, right? And much of American law is based on the English legal system, which originated in the medieval England and continued to evolve in the following centuries, right? And one of the very unique features of the common law that is judge-made law, right? The law that is made by a judge, right, or judges. And the body of principles in doctrines that form the common law emerged over time as judges decided legal controversies. Okay, and today the common law derived from the judicial decisions continue to be applied throughout the U.S. Right, and even though, as I mentioned previously, common law doctrines and principles govern only areas that are not covered by statutory or administrative law, right? However, even an area that's governed by the statutory law hold on one second. Even in the areas governed by the statutory law, the judge, right? The judge-made law continues to be very important because there is a significant interplay between statutory law and common law. And many statutes, especially codified, right? The code codify existing common law rules, and the courts, when they interpreting statutory law, often rely on common law as a guide to what the legislators intended. Okay, so to have some background note to understand, so you can understand more of common law of contract. Statutory law, right? Sorry, we have here the UCC, which is the Uniform Commercial Code, right? Okay, the Uniform Commercial Code. By looking at the name, what do you think the UCC is? What is the Uniform Commercial Code based on the name itself?
Miss, may I answer?
Yeah, sure.
Okay, so the Uniform Commercial Code is the set of rules, and they are regulate on the commercial transactions in the United States.
Okay, thank you.
Yes.
All right, thanks, Khánh Linh. So anyone else? Exactly. So Lynn actually mentioned the essence of the UCC, right? UCC, Uniform Commercial Right Code. So uniform means what, right? It means they want, the drafter would like to create the uniformity, right? Related to uniformity in terms of regulations on commercial transactions across the United States, right? Because as you have known, you studied tort before, you study other courses related to the U.S. law. The U.S. law, America, the U.S. has a legal system different from ours, right? Vietnam's. So they have the federal system and the state system, right? The federal system regulates certain issues, right? Why the state gonna regulate certain issues as well, right? It's not like in Vietnam, right? We have like if we have the problem with the one issue, then we're gonna file a law case against one party at a Ho Chi Minh City level of the city level court, right? And then later on, if there's anything, not the district court, and later on we have any problem, we're gonna move up the ladder. But in the U.S., some of the problems are that, but some can only be taken by the federal legal system. Okay, so and before in the earlier years of the U.S., the sales law varied from state to state, and this lack of uniformity complicated the formation of multi-state sales contracts. Right, for example, Lynn and I and me. Right, I'm from New York, Lynn is from California, me is from New Jersey. We have a multi-party contract, right? And each state, New York, New Jersey, and California, has their own commercial law. And of course, it's going to create a headache, right? A headache because we don't know which one that we should choose as the governing law of the contract. And our understanding of commercial law regulating that transaction is different, right? So, and the problems in the US become more and more complicated in the late 19th century as multi-state contracts become the norm. Right, before people just do very small businesses, they just deal with the people in the neighborhood, in the state, and then when it is more developed, then they start doing across the states, right? So, and for this reason, a numerous attempts were made to produce a uniform body of laws relating commercial transactions, right? And the UCC, which was first drafted by the National Conference of Commissioners on Uniform State Law in 1952. Okay, they actually proposed there are some two uniforms, right, and then two models, and then later on they integrate those two into a comprehensive body of statutory law. All right. And another one that you can see here, restatement of contract, right? Restatement second of contract, it means there's the first, right? So the restatement of contract, right? It is what? It is a compilation. It's a combination, right? Compilation of contract law principles as agreed upon by the drafters. Okay, and please pay attention that the restatement is not law. It is actually like other secondary sources of law. However, lawyers and judges often refer to it for guidance in contract disputes because of its reputation, of its, how can I say, what word should I use, of its stature, right? Or stature, maybe you know that word, stature. Sure. Okay, so of its stature. And in 1932, right, American Law Institution actually an American Law Institute is a group, right, comprising of law professors, judges, and lawyers. They actually completed the first restatement of the law of contracts, right? And with an attempt to codify and systemize the soundest principles of contract law gleaned from thousands of often conflicting judicial decisions, right? And Again, this is the product of a private organization. The restatement did not, therefore, have the force of law, but it is considered judgment in the leading scholars in the legal profession. It was highly influential in shaping the evolution of contract law because courts have an option of adopting the restatement second of contract law, of the law, the restatement second of the law of contract to as an approach to the contract issues presented in the case that actually come before them. Okay, so restatement of contract law, in short, it is not a law, okay, but it is highly, it has a very good reputation because it was drafted by very well-known people in the legal profession, and it has an option. The court gives us an option of adopting the restatement approach to the contract issues presented in the case come before them. Okay, and as like in Vietnam, you have a contract, but contract about what? A contract of purchase and sale, is a lease or employment law, employment contract. So there are other specific substantive law, okay, related to contract, are also sources of law in the U.S. Do you have any questions so far? All right, next one. In Vietnam, how about in Vietnam? Right, they say that we have statutory law and we also have case law, right? But since even though you have not studied contract law, but you may have encountered, you may be working, interning. So if you step back, right? If you step back and someone asks you, what are the sources of law in Vietnam? How would you answer? Okay, let me turn on my camera to see if it works. If someone asks you, what are the sources of law in Vietnam, how would you answer? If you are working, interning in a law firm, and your partner or your managing partner asks you that question, how would you answer? And they are foreigner. They're foreigner. How would you answer that? just if you base on the sources of contract law in the US, so is there a thing that if we step back and give a bigger picture in the US, we very zoom in, and if you zoom out, because we are in Vietnam, right? So we know of the Vietnamese legal system more, and so what would it be? What would the answer be? Maybe give me some thinking, and then let me know what do you think. Okay, so I give you guys a little bit of hint. Okay, so we have Vietnam, right? Under the Vietnamese law, we have the first one. What is the typical sources of law in Vietnam, guys? The typical one. Do you have any problem listening to me? Why are you guys so quiet?
Constitutional law.
A constitutional law, yes. So that is what type of, is it a common law? Is it a case? Is it a precedent? Is it legal normative documents? What kind of source is that?
Statutory law.
Yes, statutory law, right? So the first one is we have different sources, right? In the US, I will give you the overall pictures, right? So we have statutory law, and the most important one is the Constitution, right? Right, let me write this one. Constitution. Okay, so even though it is not frequently applied by the court, but it did, right? So far, the court has applied the Constitution in some cases, even though it is not very popular, but it is one of, right, as the Constitution, the mother law of the land, right? What else? Yes, thank you. What else? What else that we have? Everyone. Maybe let me turn off the video so the connection is better. What else that we have?
The civil code.
The civil code, exactly, right? That is a very, very important instrument, right? The second one we have is the civil code, the current version. Is the 2015, okay? And at the law level, we have the civil code, and related to the substantive matter of the law, of the contract, we also have like, commercial law or land law or other parts. Okay. Anything else? Anything else? Who just answered it? I'm sorry.
It's Châu Long, Miss.
Okay. Thank you. Any other, what other types of documents?
So it could be legal custom.
Legal custom, yes. Can you please elaborate on that more, E?
Yes.
What do you mean by that?
So could you repeat your questions?
Oh, sorry, what did you say? I didn't get that sentence. What did you say again?
I think legal custom.
Yes.
It-
What do you mean?
Yes, legal custom are supposed to be those of a community that are recognized by the state and raised into law.
Okay. Yes. Can I understand you? But can you please give an example, maybe, for your classmates to understand it better? Legal custom, do you mean like customary practice? It's like the rule of behavior and which was formed and repeated many times over a very long period and has been recognized and widely applied in a certain area or religion or ethnicity or resident community. That's what you meant? Ying, are you there?
Yes, Miss. Sorry. Let me check it out more.
All right, sure. Yeah, no worries. Okay. So anyone else? Next one. If we just look at the legal the normative documents, right? We have the constitution, civil code, the law level. We have civil code, commercial code, land law. Only kinds of law that specialized one that regulating the substantive matter. What does it mean, substantive, guys? What do I mean by substantive? What is substantive law?
I think substantive law is the law that regulates things in general.
Things in general. Can you please more specify? Elaborate on it.
For example, constitution or civil code. Technically, we can see we based on the spirit of constitutional law to draft and to build other kind of law.
Okay, so how about commercial law? What is that? Is it substantive law?
Well, I think I might be wrong.
No, okay. So yes, okay, thank you. Anyone else want to try? This is crucial, huh, guys? This is important, the things that you need to take with you after graduating. What does it mean, substantive law? If you can give an example, it's fine. If you don't know how to define it.
Oh, I think I understand it. Substantive law is like the regulation, like you read from one particular document. But on the other hand, we also have something called procedural law. And may I give the Vietnamese interpretation of that?
Yeah, sure.
So I think that substantive law is luật nội dung, and procedural law is luật tố tụng.
Very good. Luật hình thức ha.
Yes.
As the name itself. So substantive law actually provides the rights and obligations of certain entities or the people, while procedural, as the name itself, right, how things should be carried out, right, how the substantive law should be carried, especially the steps and the proceedings at the court of law. Okay, so substantive, tiếng Việt là luật nội dung ha các bạn, rồi và procedural law là luật hình thức hoặc luật tố tụng. Cái này mình biết rất là rõ, những cái khái niệm rất đơn giản thôi, nhiều khi mình không có để ý ha. Alright, good. Next one. So that's why I say, even though we know contract law, but there are certain other specialized law that we need to know as well, because it will regulate the substantive matter of the contract that you are dealing with. Like, for example, contract on the employment contract, then you need to know employment law. And if the contract is regarding shipping, or on a buying and selling something, right? If it be a car or cars or TVs, things like that, then definitely you need to know commercial law, etc. Okay. What else? The next level, what is that? You guys study constitution already, right? So what comes after the under law? What is that? In the hierarchy of the legal documents in Vietnam, under the law is what? I'm going at the hierarchy, so it's easier for you to look at, right from top to the bottom. What is it? Under the law is what?
I think under the law is a decree.
Before the decree.
Circular.
Oh no, circular is under decree. Before that. So the circular is ranked below decree, right? So what is above decree?
Decision.
No. There are a lot of things that they are that kind of document before they become a law. For example, we have arbitration law, right? Before it becomes the law on commercial arbitration, it is that kind of document.
I don't understand. No. Sorry.
Yeah, no worries. So what is below the law but above the below decree, guys?
Resolution.
Resolution. Okay. What resolution of by whom? Provided by whom?
I think ordinances and yes.
Yes, ordinance. So that would be ordinance. Okay. So the next one could be some ordinance related to the topic that we are discussing the subject matter. Like for example, right? If you have dealing with like foreign currency, Then there is a very famous one, which is the ordinance on the foreign exchange of foreign currency control. Okay, pháp lệnh về kiểm soát ngoại hối ha. Right. So, and there are other ordinances related to contract law that is a source to regulate the contract law in Vietnam. Okay, and underneath that we're gonna have decree, right, and circular, like you guys said, circular, right, and then we're some resolution by the council of judges. The council of judges. Okay, so hold on, give me a second. Where is my screen? All right. So besides the normative documents, we also have in practice, right? In practice, or not a second branch, right? Which is in practice. So what are those that what do we mean by in practice, which is the second branch, right? So what are these?
I think we have case law.
Case law, okay. Hold on, give me a second. Okay, I'm very sorry, guys. I have a very important phone call. Okay, so what did who had just answered something? Could you please say it again? Hello?
Yeah, sure.
Yes,
I
ma'am.
said case law.
Okay, case law. Yep, agreed. Right. So you think that it is case law. What I would like to, yes, that could be case law. Hold on. Anyone else? Anyone else, please? Or precedent, right? Oh, that is the name that we use in Vietnam when they translate that. Precedent number something something, right? What else? Before, right? One of you mentioned customary practice, right? And you can only see that in it's regulated. It is regulated in the civil code as well, Article 5. Okay. Besides that, there is also other, which is this is a little bit not difficult, but you might have known. So another one could be how can we say the moral, social morals. Okay. Social morals. Okay, that could be another one, right? If you look at Article 3.2 of the Civil Code, you're gonna see that, right? And other one would be the judgment, right? The case law precedent or the judgment or the decision of the court, okay? Judgment or decision of the court, all right? Is it enough? What else that we have here? What else that we have?
I think it might include international conventions.
Yes, it might include international convention. Yes. So if the contracts that are that have involved international elements, right, then definitely, right, a very very good one. You the foreign elements, you need international treaties, right? For example, it's related to sales of goods, then you need a United Nations Convention on International Sales of Goods, CISG, right, or the Vienna Convention, as we will usually call, or you can use Intercom. I'm sorry, Intercom, Incoterms, right, or anything related to LC. Of course, all of these you can look at the President number 13, right? Án lệ số 13 ha. President number 13 of our country, right? Very good. Thank you. Any others? What do you guys think? Any other sources? Another one, right? If you read the civil code, you're gonna see that, which is we can say maybe the another one, which is the other thing, right? This is practice. This is legal document. Okay, normative documents in practice. E. And sorry, it's not very easy for me to write here. That's why, and others, right? So if you pay attention, you can look at the civil code. They say article number 6, right? Which is application of analogous law. This is analogous law. Okay, Article 6, you can see that. Okay, and besides that, the Civil Code also mentioned equity. Okay, it also mentioned equity. So, hold on 1 second. Okay, so if you look at article number 6, you want to see that. All right, and they also mentioned that application of analogous law, right? And what is it about? How is it specifically? Please go home and read the Civil Code 2015. Okay. And of course, there are other issues like, for example, if there's a conflict, right, between a general law such as the Civil Code and the specific law, like for example the commercial law, then how it should be dealt, right? And if you can look at the Article 4.3 of the Civil Code, right, and to see what is what do they think should take precedence over the other thing. Okay, and if between the law, a new law, and the old law, for example, the Civil Code 2015 and the Civil Code 2005, right? If there is an overlap, right, or the transition between those laws, so those codes, so what should be applied, right? You can read in Article 688 of the Civil Code 2015, and you can see that. Okay, do we have any questions so far for this part? I give you the very detailed picture instead of the very general one like in the slide. Does it help? Is it okay? Do you have any questions so far? Okay, if you do not have any question, then we're gonna continue. All right, let's continue. Okay, so this one, we're gonna move to the third one, which is the classification of contract laws under the US. Okay, the three subcategories that we are looking at is based on formality, validity, and performance. Based on formality, we're gonna have formal, informal, expressed implied impact, implied in law, bilateral, and unilateral, okay, under the US law. So first, look at formal and informal, okay? So please spend maybe 1 or 2 minutes, read the slide, and then we will discuss what do we mean by formal and what do we mean by informal contract. Okay, so what are formal contracts? How would you understand this? And um, maybe you can give me an example, right, based on what you have read on the definition, that the knowledge that you might have known before coming to the class. So how should we understand the concept of formal contract? What is the formal contract, everyone? Queen, yes, please.
So I think formal contracts must be written, and they have to have like situations as follows, like contracts containing essential terms such as day of completion or day of payment, or keep a degree of secret between one party and the other party.
Okay.
Filing employee agreements so that the employee understand their rights.
Okay. All right. Thank you. Thanks, Queen. Anyone else? What do you guys think? Any other thoughts?
I think formal contracts also require, like you mentioned, a special form. Besides in a written form, is also some contract require administrative procedures to make it valid.
Okay. All right. Thanks, Phụng, right?
Yes.
Okay. Thank you. Anyone else? Please keep in mind, we are talking about the U.S., not Vietnam yet. We have not discussing. We have not discussed the Vietnamese in terms of Vietnamese law yet. We are discussing in terms of the U.S. law, right? The U.S. contract law, based on the information that you have read, right? Or maybe something that you found online. So how should it be? How should a formal contract should be understood? Okay, so this one is a little bit not very familiar to you guys, right? So a formal contract, exactly, are contracts that require to a special form or method of creation, right, or formation, in order for it to be enforceable, right? So later on, since this is the first class, later on you can go home and read a restatement second, section 6, right? They actually explain what formal contracts include. Okay, they're gonna point it out that certain documents are considered as formal contracts. Okay, so and one example, as you can see on the slide, is the negotiable instrument, right? Negotiable instruments. What are negotiable instruments? Anyone? Does anyone know? What does it mean, or what does it mean in Vietnamese, if you may know, or what are they? Give me some example of negotiable instruments. Sorry, can you guys hear me? It's raining in my area, so right. So what are negotiable instruments, or can you give me some example of a negotiable instrument that you have, that you might know, or maybe the definition of negotiable instruments? Negotiable instruments include what? Include check. When you write a check to someone, right? Include check, draft, or like maybe bill of exchange, right? Or maybe the certificate of deposit. Okay, and why they are a considered as a formal contract? Because under the UCC, right, a special form and language are required to create them, right? It is pretty different compared to those under the Vietnamese law, right? Another one, which is letter of credit. You know, letter of credit, LC?
Yes, we know.
Yep. Okay, good. Letter of credit, right? They are frequently used in international sales contracts, right? And those are agreements to pay a contingent on the purchaser's receipt of invoices and bill of lading, right? Those are the terms in international sales, right? So those are also the letter of credit, also an example of formal contracts, right? So when we hear something formal, we thought that it should be in writing, right? But under the US law, it's not just like that, right? It requires more, right? There must be in a certain format, must be in certain form. There are specific type of language required, okay? Informal contracts, this is very easy, right? Whatever is not formal contract or informal contracts, very, very straightforward, right? So informal contract, sorry, sometimes are called simple contracts, include all other types of contracts which are not formal contracts, right? And there's no special form is required, except, of course, there are certain contracts must be made in writing, right? We will study that later, statutory fraud, right? And at the contract, they usually based on the substance and rather than the form, right? So typically, businesses usually put their agreement in writing, but not all of the transactions are required to be writing, because that is just like some proof of a contract existence should any disputes arise, okay? So again, generally what we are dealing every day, like employment contract, leases, like, you know, purchase, sales and purchase contracts, those are actually informal contracts under the US law, okay? Next one, we have another subcategory, which is express contract, implied in fact, and implied in law. Okay, so let's first look at the word. What does it mean when we say express or implied? What do express and implied mean? What do an express or what the word itself? What do we mean by express or implied? When we say express or implied, what do we mean by that?
I think that when we say express, we mean everything need to be in written form. no interpretation or no ambiguity.
Okay, everything must be in written form. No what and no ambiguity.
No interpretation.
No interpretation needed. Okay, all right. No assumption. You mean that's what I
Yeah,
said?
no assumption.
Okay, no assumption. Okay. Yep. Anyone else? Thanks, Nghe. Anyone else? Okay, so express like the word itself very, very clearly, right? So express contract, it means what? The terms of the agreement are fully and explicitly stated, okay? And stated in words, right? It can be oral or written, okay? It can be in both forms, okay? It can be either oral or written form, that would be fine, okay? Example, right? If you come from another province, right? And then you need to rent an apartment to live in Ho Chi Minh City to go to school to study. Then the lease between you and your landlord is actually stated out all of the duties and obligations and the rights of each party is actually a express contract in written form. Okay, and then however when not however, besides that, right? When Nghe needs to buy a textbook of law of contract, and Nghe knew that Hoàng Yến, right, has two books, right, two copies. So Nghe gonna call in say, hey, I need a book too, and I knew that you have two copies, right? So how much is that? Right? Say, oh, $10 each, and Nghe agreed, right? So that is actually an express oral contract, right? And the express oral contract actually has been made between Yến and Nghe, right? So those are three examples. So again, express contract means that the terms of the agreement are fully and explicitly, okay, stated in words, right? It can be oral or written, okay, orally or in the written form. It's implied. How about implied? What do we mean by implied?
I think implied contracts are met between party based on their action and their behavior of the party involved.
Okay. Hoàng Yến, right?
Yes. Yes.
Yes. What am I note? Okay. So exactly. So implied, right? As the word actually, you know the word already, especially when we learn English before, right? What does this sentence imply, right? What does the speaker imply, right? So implied, the contract that is implied from the conduct of the party, right? That is implied contract, but actually it is implied in fact contract, right? We have two types, right? Implied in fact, implied in law. So we are talking about implied in fact, right? So, and sorry, other. All right. So this type of contract differs from an express contract. How? Right? And the conduct of the party, right? Rather than their words, create and define the terms of the contract. Okay, again. So an implied in fact contract differs from an express contract in that, right, the conduct of the parties, right, rather than their words, create and define the terms of contract. All right, so there are some requirements, right? There are some requirements for an implied contract to actually exist, right? We need to meet the checklist, right? So the first one is that the plaintiff furnish some service or property, okay? And the plaintiff expected to be paid for that service or property. And the defendant knew or should have known that the payment was expected. Okay? And the third one is that the defendant had a chance to reject that services or the property, but the defendant did not. Okay. Example. Nga is very good translator, right? And she, okay, hold on, give me a second. I need to close the window. Right. Sorry, I don't know why it's raining very heavily in District 7 right now. So, and I knew that, right? And I need, my company needs a very good translator because we are having a meeting with our foreign partner, right? Business partner. And I talked to Nga, right? And then I talked to Nga, and I know that the Nga gonna charge usually 400,000 per hour, right? 4,100 Vietnam dong per hour. Okay, and I talked to her yesterday, and then today, right? I asked Nga to come to my office, right? And then Nga walked into my office and she just saw a little group of people there. And then I just left Nga there and then walked out. So Nga saw a group of people, right, with my manager who doesn't know how to speak English, right? So she started translating. Right? And in this situation, what happened? I actually have entered into an implied contract to pay Nga the usual fee, right, for her services. Okay, and the contract is implied because of my conduct, okay, and Nga's conduct. Okay, so Nga expects to be paid, right? So after 6 hours, right? Nga expects to be paid for completing the whole meeting, right? Which lasted 6 hours, right? And I have implied an intention to pay her. Okay, so in this case, I did not say anything, right? I asked Nga, could you please come over and be my interpreter for the meeting with my foreign partner on the 22nd of February 2020 at 9 a.m. in my office? No, I didn't say anything. She didn't say anything either, right? But, right, because I asked her about the services, about the fee, and then I asked her to come to the office and leave her there in the setting, in the context of, you know, she needs to translate because everyone looking at each other like, who's talking about what, right? And Nga is the only person who knows. So by my action, by my conduct, and by Nga conduct as well, she actually started translating. Okay, so it's implied that there has been a implied contract between me and Nga, and I have to pay Nga the usual fees of services that she is deserved to receive. Okay, so if I did not pay Nghe, and then Nghe can actually sue me at the court of law because between us actually have a implied in fact contract. Is it kind of clear? Yes, no, maybe? Is it clear, everyone? Okay, good. Thanks, Nat. Right. So there are some contracts, right, that they can also have both express term and implied terms at the same time. Can anyone think of an example where it has both, right, implied terms and express term at the same time? An example, right? No, not yet. So maybe you can think and then we can discuss later on. All right. So the last one would be implied in law, right? It means what? It means there is no actual contract and imposed by the court to avoid any, oh, hold on. Unjust enrichment, okay? Imposed by the court to avoid any unjust enrichment. Okay, so what do we mean by that? What do we mean by that? It means that there was no contract at all. Okay, there was no contract at all, but an obligation imposed by law to do justice, even though it is clear that no promise that was actually never made or intended. All right, let me give you an example to be clearer. There is a pool, right? Swimming pool, right? A is the mother, B is the kid, all right? The mother was, playing with her phone and the kid fell off to the swimming pool, right? 2-year-old kid. C is the doctor sitting right next to the pool, right? Saw that B fell off, saw B falling off to the pool and actually run to the pool and, took B off the water and do some, how can I say, medical care, right? So does A have to pay for C? Does A have to pay C for rescuing B, who is her child? Do you think that A has to pay B, A has to pay C for rescuing her child? Do you get the scenario? Do I need to repeat again? Okay, let me stop showing this. Stop showing this. I'm gonna share something else. All right. Okay, here, right? Let me clear this. So this is the swimming pool. This is B. This is the chair, right? And this is the mother playing with her cell phone, right? And this is B. This is A. A and B is the mother, the relationship. And C, right? Standing right here, okay? B fell off the pool. Mother playing the phone, did not know anything, right? C saw that, okay? Run to the pool and help B, right? And did some medical care. So B is now completely fine, right? The question is, does A have to pay C for the medical care? Does A have to pay C for helping the child?
I think she does. She
She
has
does.
to pay.
Okay, why? Why nghe? Why do you think so?
Because I think that C, as someone who is a professor in medical field, and
Yes, it's the doctor. Yes.
yeah, C is a doctor, and C has provided, I don't know, relevant supportive assistance. Then C deserves an amount of payment for C's action.
Okay. But there's no contract between A and C. I did not ask C to do anything. C did it voluntarily.
Well, if A did not ask C to do anything and C actually did not do anything, then it will cost B life, and then A will blame C for not doing anything.
Okay. All right. Okay. Thank you. But B. Okay. Thank you. Yep. Agreed. Thanks, Nghe. Anyone else? So the answer is yes, right? Anyone else? What do you guys think in this situation?
I think the mother need to pay medical care because the responsible for case is also the mother, and the mother is the guardian for the child, and the child is not yet capable to repay for C.
Okay. Right. So you also agree that it's a yes, right?
Yes.
Okay. So implied in fact, right? There is another name for it. It's called the Quanzai Contract. And so let me clear this drawing for anymore. Stop sharing. Okay. So we have Quanzai Contract. Right. So Quanzai Contract, or in other terms that we actually use with the slide, is implied in law contracts are not actual contracts, right? Again, we don't have an actual contract between the parties. And express contract and implied in fact contracts are actual or true contracts formed by either words or actions of the party, right? The Quanzai contract in Latin, right? Quanzai means as if, right? Or analogous. Right? So in Latin, Quanzai means right as if or analogous to. So Quanzai contracts are not true contracts, right? Because they do not arise from any agreement, right? Either expressed or implied between the parties themselves, in this case, between A or B and C, okay? Rather, it is a fictional contract that court can impose on the party as if the party actually have entered into an actual contract, right? And it is actually equitable, right? Then it is considered as an equitable rather than a legal contract. All right. So, equitable doctrine of a Quanzai contract allows a court to award monetary damages to a plaintiff, right, for providing work or services to defendant. So plaintiff here we C and the defendant is A, right, or B, even though no actual contract existing between the parties. And what is the why we have this doctrine, right? The doctrine of Quanzai contract is intended to prevent unjust enrichment, as you see in the slide, or another one is unjust detriment. Unjust enrichment is for, if we look at the perspective of A, right? And unjust agreement is that we're looking at from the perspective of B, right? The doctrine is actually based on the theory what? The theory that an individual should not be allowed to profit or enrich themselves inequitably at the expense of others, okay? Again, right? An individual should not be allowed to profit or enrich themselves inequitably at the expense of the other, right? So a Quanzai contract is actually imposed when one person confers a benefit on the other who retain a benefit, and two, it'd be unjust not to require that person to pay for the benefit that received. Okay, so there are a lot of cases related to that, and let's see, maybe we can look at some of the cases later on. Okay, so for now, right, we will look at on Tuesday. On Thursday, we will take more time to look at the classification of contract, and if we have time, we can look at some examples to clarify this, right? Even though I give you a very brief example, but maybe we can have a more complicated, comprehensive scenario, right? So we understand the context more. Okay, so I think let's stop here for the first class. It has been pretty long and intense already, right? So after the first one, do you have any problem with the way that I deliver the material to you? I would like to hear it now, right? So I can adjust it for the benefit of yours. And then, you know, the earlier you tell me, the more benefit that you will get, right? So do you want me to, how would you like me to adjust my delivery? I'm willing to listen to your feedback, and because every class is different, right? So I'm not sure how it works with your class. Is it okay right now? You want it to be faster? You want it to, how you would like me to slow down? More examples, or to explain each concept more, or what? Is there any feedback so far? Okay, if you don't feel comfortable talking to me, then you can discuss with your with Nghe or with your monitor. Okay, they can directly tell me, or they can email me. Whatever way is fine. All right. So for now, please have a look again. Review the materials that we went through today, and then thank you. I saw that one of you say give more example. Sure, right? I will try to give more example later, right? I believe that